Thus you understood the importance of Shahla admission. Principal Mamour.
Of course, Mr. Azam. We can ensure that Shahla will take your rightful place.
Okay, I trust you.
Walaikum assalam. Yes, Amina. Oh, you're Amina, right?
Yes. I came to get medicine for headache.
Here.
Thank you. Thank you. Shahla, Shahla, wake up. Shahla, Shahla, wake up. Shahla.
How is everything going? Can I help you with something?
Oh yeah, could I check the cameras please?
I apologize, but on that day our cameras weren't working.
Then could you please send me the list of every person that entered the school that day? Thanks. By the way, can I ask some questions real quick?
Why not?
So how long have you known Shahla? Did you know her before she got accepted?
So many questions. Alright, I will answer them one by one. I didn't know her at all. Obviously, I know her dad. She got 24th place in the entrance exam. I got to know her after she came to school, like I did with every other student.
Thanks for your help.
You are welcome.
Good evening, Miss.
Telfuza.
Csi.
How can I help you?
I'll be asking you some questions about Shahla's case, and all you need to do is answer them.
With honesty.
Glad we understood each other. Shall we begin?
Yes, please.
When did you start working at this school? And were you familiar with Shahla or related to her in any way?
I joined at the start of this academic year and I met her here. I didn't know her before.
Where were you when the incident happened?
I usually sit in my room and I'm pretty sure I was there when it happened. I suppose it occurred at night.
Yes. One more question. How did you find out about Shahla's case?
I heard Amina scream and came running to her room. I apologize, but I have to go. I have a night shift today.
Oh, okay. Thank you. Hello, I'm Asrar, and I will be conducting the inquiry into Shahla's case. I understand you were close to Shahla. Can you describe your relationship with her?
We weren't best friends, but we had a decent relationship. Most of our disagreements were about our parents' social statuses. Despite that, we didn't spend much time together, but the school assigned us as roommates because of our conflicts, and that's all.
I see. How was she on her day of passing?
We had a buckwheat for dinner, and I asked her how she was feeling, and she took her usual medication for her day.
Where were you when she passed away?
I'm not entirely sure what happened. When I wake up, I try to wake her up, and when I checked on her, she looked pale and had no pulse. I screamed, and that's when the teacher rushed out.
Does she have any known allergies or take regular medications?
I don't believe so.
Alright, thank you for your cooperation. I'll reach out if I have any further questions.
Okay.
This it's oddly familiar, almost like bitter almonds. Who would even think of putting cyanide in a child's food? Good afternoon, mister. Good afternoon. You are the last interviewee for today, so let's get started. Okay.
So can we start?
Yes, of course. Firstly, what's your name? And where were you when the incident was occurred?
My name is Ilsan and I was at home that day.
Does this scene trigger any memories for you? Mr. Mamour.
What happened? Please.
I need to inform you about something important. It's urgent. It took me some time to realize it, but I found evidence to support my hypothesis. The chef poisoned the girl's food. You can still go back. It's gonna be over.
Your Honor, my name is Maftuna, representing the prosecution in this case. This case is about unfortunate death of Shahla, young student with a promising future. On the evening of May 1st, 2024, My client Shahla died because of a poisonous drug she took. This drug was given to her by the school nurse. The defendant, Dilfuza, held a position of trust as a school nurse. This trust was breached in a severe manner. The prosecution will demonstrate that Dilfuza utilized her medical knowledge to administer a poisonous pill to Shahla. In a sense, she did not simply prevent Shahla from attending the school. She caused her death. We have some compelling evidences against Dilfuza. The presence of a poisonous and illegal drug, which immediately kills a person within 1 hour, was found in her bag during a routine police search. There is complete absence of any medical justification for their administration. Shahla's medical analysis showed that she was poisoned, but no food was found in her stomach, which shows that she was not poisoned with food. Your Honor, Dilfuza's mental health results showed that she has not any medical conditions. So when considered collectively, these facts suggest Dilfuza's intentional act. I believe that Dilfuza should face 2 distinct charges. The first is murder, under Article 97 of Uzbek Criminal Code. Second is the defendant is charged with possession of illegal drugs, a violation of Article 201 of the Criminal Code. Furthermore, the severity of Dilfuza's actions goes beyond these violations. Article 56 of the Criminal Code acknowledges aggravating circumstances that warrant a more significant sentence. In this case, the circumstance is undeniable. Shahla was a child. Dilfuza's actions resulted in a death of young life. Furthermore, she violated the trust placed in her as a medical professional. Shahla's life was tragically cut short. The state of Uzbekistan seeks justice on her behalf. We seek to hold Dilfuza accountable for her deliberate actions and ensure such a tragedy never befalls another innocent child. That's all, Your Honor.
Your Honor, my name is Sardar. I stand before you today representing Ms. Dilfuza. While Ms. Dilfuza acknowledges the gravity of your actions and accepts the charges brought against her by the state, I would like to present some mitigating factors of your kind consideration during sentencing. As you are aware, Article 50 of Uzbek Criminal Code offers specific considerations for male defendants. Specifically, the maximum term of imprisonment for women may not exceed 3/4 of the maximum penalty prescribed by the relevant article in the special part of the Code. We urge the Court to take the provision into account when determining an appropriate sentence for Ms. Dilfuza. Furthermore, it's crucial to acknowledge the underlying circumstances that tragically led Ms. Dilfuza down this path. The loss of your daughter to suicide due not to get accepted to presidential school in Tashkent because of unfair testing and corruption. Your Honor, my client would like to give your last speech.
I understand why I did something unforgivable, but I don't regret it. This situation isn't entirely my fault. I did what I did because of the immense grief over my daughter's suicide. My daughter was kind, intelligent, and talented enough to get into this prestigious school. I was convinced she could pass the entrance exam, but unfortunately she didn't. While she was at the top of the wait list, a different student was accepted instead. Initially, I believed the selection process was fair. However, everything changed when I saw Mr. Arabek's child at the school. Here's the crucial point. She never took the exam. When I returned home that day, I found my daughter dead. She had taken her own life, consumed by depression. In my eyes, the unfairness of the situation, the school's corruption, ultimately drove her to suicide. They took her future away. My intention was never to harm Shahla. I wanted revenge for my daughter, who became victim of corruption.
We diligently considered the evidence presented by both the prosecution and the defense. The court finds Ms. Dilfuza guilty of murder under Article 97 and possession of illegal narcotics under Article 120 of Uzbek Criminal Code. We will give Ms. Dilfuza 15 maximum years for killing one person and 3 years minimum for illegal drugs is given. The death of Shahla is a tragedy. A young life has been cut short. However, the defense's arguments regarding Ms. Lufouza's emotional state are acknowledged. While grief does not excuse a crime, it can provide context. Taking into account these mitigating factors outlined in Article 15, the court sentences Ms. Lufouza to 13 years imprisonment, with the sentence not exceeding the 3/4 maximum penalty as mandated by the law for female defendants. However, taking into account the aggravating factors, which includes killing the child, 5 years imprisonment is added. In total, for Ms. Lufouza, 18 years of imprisonment is given. Following the Article 15, Ms. Lufouza will spend her imprisonment years in colonies of general security. The court has heard the evidence and considered the arguments presented by both sides and made this decision.
Your Honor, my name is Maftuna, representing the prosecution in this case. This is a case of a director of residential school in Tashkent, Mr. Mamour, who committed several crimes, including trying to kill a person, possession of pistol, and trying to shoot a detective and taking a bribe. Mr. Mamour's first crime was committed on May 1st, 2024. He worked with the school cook and tried to poison Shahla's food. Thankfully, Shahla didn't eat it. But Mr. Mamour's plan is clear. He tried to kill her, which is a crime under Article 58 of our criminal code, attempt murder. Secondly, Mr. Mamour also had a gun without a license, which breaks Article 248 of the criminal code. On May 5, 2024, he tried to kill a detective, Mr. Asrar, who was working on Shahla's murder with the gun. A school principal should follow the law, as he has so much responsibility. He was supposed to keep students safe. Your Honor, as an evidence, we invited witness, so I would like to conduct a direct examination with him.
Would you please state your full name for the court?
Asrar Halimov.
Would you like to affirm or swear on the book?
Affirm.
Do you swear that the evidence you are about to give is only the truth?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give be the truth, the whole truth, and nothing but the truth.
You work as a detective and worked on the case about murder of Shahla, right?
Yes.
How did you notice that Shahla's food was poisoned?
When I was outside, I smelled a strange smell. When someone was taking out waste food out, I was sure that it was the smell of strong poison, as my previous cases also included this poison.
What did you do after noticing it?
I reached the director's room to tell about this, as I thought that food was poisoned only by the cook.
How did the director react to it?
I am a detective, and my voice recorder is always turned on, so I can show you a voice recording of the director's reaction, if you allow.
Your Honor, can we listen to that voice recording?
Sure.
This evidence clearly shows that he tried to kill Shahla. Furthermore, the severity of director's actions goes beyond these violations. Article 56 of the Criminal Code acknowledges aggravating circumstances that warrant a more significant sentence. In this case, the circumstance is undeniable. Shahla was a child. The defense might try to explain away Mr. Mamour's actions or make them seem less serious as it didn't cause Shahla's death. But the evidence is undeniable. Mr. Mamour planned to poison a child and had a gun he shouldn't have. These actions put not only Shahla, but the whole school at risk. This court needs to give a sentence that reflects the seriousness of these crimes. We need to send a message. People in positions of power will be held accountable for their
Your
actions.
Honor, while Mr. Mamour takes responsibility for the seriousness of the situation and the charges against him, there are reasons to consider a lighter sentence. Two of the situations where punishment should be less are present in this case. First is that Mr. Mamour deeply regrets what he did. The second is that he committed this crime because of the threat done by Shahla's father. Your Honor, my client Mr. Mamour would like to talk about this. Your Honor, as you know, I'm the director of the best school in our city. Threat done by Shahla's father was about firing me from my work. He is really powerful, so I was scared, as I love my work and students so much. I was forced to accept Shahla's admission, which was unfair to others. I was scared that if someone would find out about it, I would lose my job. So to keep the school's reputation high along with personal struggles, I decided to do this. I really regret what I did. Thank you.
Your Honor, can I ask a question?
Defense lawyer, do you agree?
Yes.
Okay, then go ahead.
While replying Mr. Atabet, we admitted that he also gave a bribe to you. Is that correct?
Yes.
You said that you want to kill Shahla only because of the pressure her father put on you. If he only just threatened you, why did you take a bribe he gave you?
Yes. I didn't know what I was doing because of the pressure and
That's all. Thank you.
Your Honor, as my client mentioned it, he took it because of the pressure he felt and under the influence of fear. In Article 210 mentioned only the punishment for those who took bribe with self-consciousness. I want you to consider this and lighter my client's punishment for taking a bribe. Even so, nothing excuses his actions. Understanding the situation is important. We ask the court to consider factors mentioned by us when deciding on a sentence. That's all. Thank you.
We have carefully reviewed the evidence presented by both the prosecution and defense. The court finds Mr. Mamour guilty of attempted murder under Article 58 and the illegal possession of firearm under Article 248 of the Uzbek Criminal Code. Trying to hurt a child is a terrible crime. While problems don't excuse a crime, they can help explain it. Considering the reasons presented against him, the court sentences Mr. Mamour to 12 years in prison. This sentence includes 3 years for owning a pistol without license, 5 years for trying to kill a person, 1 year plus for working as a team. Also, he should pay a fine of 70 million sums for taking a bribe, which is the minimum amount of fine for this crime. We must also consider the seriousness of attempted murder against a child, as outlined in Article 56. Therefore, an additional 2 years will be added to the sentence. However, considering the defense's arguments about Mr. Mamour's emotional state and personal troubles, 3 years are subtracted. This is for regretting the crime committed and threat he got. In total, Mr. Mamour is sentenced to 8 years in prison and should pay a fine of 17 million sums. Following the Article 15, Mr. Mamour will spend his imprisonment years in colonies of general security. The court has heard the evidence and considered the arguments presented by both sides and made this decision.
Your Honor, my name is Maftuna, representing the prosecution in this case. This case is Mr. Rustam's, who's blamed for trying to kill a person and possession of illegal poison. Mr. Rustam's first crime is that he worked with the school director to make a plan to kill Shahla. On May 1st, 2024, Mr. Rustam added poison to Shahla's food. Thankfully, Shahla didn't eat it. But Mr. Rustam's plan is clear. He tried to kill her, which is a crime under Article 58 of our criminal code, attempt murder. We can take the director's confession and the detective's words as evidence for this. Secondly, Mr. Rustam also had an illegal poison, which kills a person immediately during 1 hour, Article 251 of the criminal code. Furthermore, the severity of the cook's actions goes beyond these violations. Article 56 of the criminal code acknowledges aggravating circumstances that warrant a more significant sentence. In this case, the circumstance is undeniable. Shahla was a child. These actions put not only Shahla, but the whole school at risk. This court needs to give a sentence that reflects the seriousness of these crimes.
Your Honor, while Mr. Rustam takes responsibility for the seriousness of the situation, there are reasons to consider a lighter sentence. Mr. Rustam worked with the director as a team, but Mr. Mamour was the one who planned everything and offered to cook. Mr. Rustam deeply regrets what he did, and I believe that these factors should be considered and lighter punishment should be given. We ask the court to consider this factor when deciding on a sentence.
We have carefully reviewed the evidence presented by both the prosecution and the defense. The court finds Mr. Rustam guilty of attempted murder under Article 58 and the illegal possession of a poison under Article 251 of the Uzbek Criminal Code. Trying to kill a child is a terrible crime. Considering the reasons presented against him, the court sentences Mr. Rustam to 8 years in prison. This sentence includes 2 years for possessing a poison illegally, 4 years of trying to kill a person, 1 year plus for working as a team. We must also consider the seriousness of attempted murder against a child. As outlined in Article 56, therefore an additional 1 year will be added to the sentence. However, considering the defense's arguments about Mr. Rustam's emotional state and personal troubles, 2 years are subtracted. This is for regretting the crime committed and threat he got. In total, Mr. Rustam is sentenced to 6 years. Following the Article 50, Mr. Rustam will spend his imprisonment years in colonies of general security.
Your Honor, my name is Maftuna, representing the prosecution in this case. This is a case of Mr. Otabek, who's blamed for threatening a director of presidential school in Tashkent and giving a bribe. Mr. Otabek's first crime is that he threatened the director of presidential school in Tashkent with firing him from his job. Mr. Mamour's words and Mr. Otabek's confession can be a clear evidence for this crime. He should be punished following the first part of Article 192. Secondly, Mr. Otabek gave a bribe to Mr. Mamour to accept her child to school. The envelope with huge money found in Mr. Mamour's drawer, which has a fingerprint of Mr. Mamour and Mr. Otabek, is clear evidence. This act should be punished due to Article 211.
Your Honor, while Mr. Otabek takes responsibility for the seriousness of the situation and he deeply regrets what he did, and this should be considered due to Article 55. Even so, nothing excuses his actions. Understanding the situation is important. We ask the court to consider this factor when deciding on a sentence. Thank you.
We have carefully reviewed the evidence presented by both the prosecution and the defense. The court finds Mr. Azam guilty of attempted violence under Article 192 and the corruption under Article 211 of the Uzbek Criminal Code. Considering the reasons presented against him, the court sentences Mr. Rustam to 2 years in prison and fine in the amount of 100 million sums. This includes 3 years for corruption and 100 million sums for violence. Considering the defense's arguments about Mr. Mamour's emotional state and personal troubles, 1 year is subtracted. This is for regretting the crime. In total, Mr. Mamour is sentenced to 2 years and should pay 100 million fine. Following the Article 50, Mr. Mamour will spend his imprisonment years in colonies